Can I be denaturalized for immigration violations which I previously disclosed to the government during my immigration applications? The answer is generally no. So if you disclosed your violations to USCIS, an immigration judge, or a U.S. consular officer throughout your immigration history while you were applying for various immigration benefits, then those were considered, those violations were considered, and if you were approved, the application was approved, and you obtained a green card and you became a U.S. citizen, then this cannot lead to denaturalization because you did not fail to disclose these violations, right? They were considered by the government before you were granted U.S. citizenship. Now, in some limited, very rare cases, the officer could have made a mistake and you should have never become a citizen. So basically, your violations were so extremely serious that you could have never become a U.S. citizen, yet you were still allowed to become a U.S. citizen. In those cases, technically, you illegally procured your U.S. citizenship and you could be denaturalized. However, keep in mind that the government would have to initiate this case against you and prove to a clear and convincing evidentiary standard to a federal judge that you should have never become a U.S. citizen. Generally speaking, this is extremely rare unless the violations were truly, truly major. Think major crimes that should have never allowed you to become a U.S. citizen. If you have any questions or comments, please post them in the comments below and I'll try to record more videos on this. And I will also be recording a long form video answering all these questions. So if you subscribe to the channel, you'll be alerted when that is posted. Thank you so much for watching.